Elaine Law Group just joined us.
Ooh, thank you, Jesus.
Hi, I'm so sorry. I had no idea that there were issues on Lorraine's end, but our fabulous Hezbollah is online. She let me know there were issues, and she asked me to join. So I'm here. I'm
Oh gosh.
joining.
Thank you. Thank you
No
so much.
problem.
So please, I already did the introduction. Everybody know who you are. You guys are amazing in DFW. And take it over, please.
Okay, yeah, sure, no problem. I'm Elon. I'm Elon from the Elaine Law Group. My partner is Lorraine Bearable. You guys were expecting her, but you got me. So
She's
I hope I
amazing.
can.
We are really grateful.
I hope I can shed a little light on a few things. Help us move through. Who's driving?
So you just tell me to go through the next slide and
Okay,
I'll do that. Yeah.
as Patricia.
Yes, as Patricia. Yes,
Okay.
ma'am.
All right. Thank you, Patricia. So I'm sorry. I thank you all for staying on, and I hope that you guys can grab some wealth of knowledge from this little tidbit that I'll do for you guys, and to I'm happy to jump in and help. Somebody just message. I don't have the first video.
Oh, don't
Um,
worry about that. We're gonna take care of
oh,
that. Yeah.
okay. All righty. I got to stop reading chats. I have
Please
a habit
stop.
of
Please
reading
stop.
chat while I'm presenting. Okay. All right. So basically, what we're going to go over for you guys today is what's an estate plan and the basic fundamentals of that. I heard a little bit and I second what Patricia was saying there. So, yeah, we'll just get into it. We'll talk about what's a probate, what's an estate plan, and why do you need an estate plan. We'll go through the different types of documents, the wills, the will memorandum, medical power of attorney, durable power of attorney, directives to physicians, and a declaration of guardian. Next slide. So, what's a probate? Um, I let me before we jump into it, just as a disclaimer, we are Texas licensed Texas attorneys. With this will be from the perspective of the state in which we are licensed in is the state of Texas. So I heard somebody talk about Nigeria earlier, but or other countries earlier, but yeah, we are U.S. and Texas specifically licensed attorneys, so that'll be from the lens in which we're speaking just for this day. But yes, every state, every country has different things, so just keep that in mind when you ask your questions. When we get to the Q&A, there are only some questions that I'll be able to answer, like in this forums, and some instances, like people want to go far in depth into their own personal issues, I would request that you not go too far into your personal issues, but try to kind of keep it very surface level. And then if you like, you can definitely schedule a consultation and we can delve deeper into like more personal matters. But what's an estate plan or what's a probate? Probate. A probate is the process by which the court actually legally recognizes the death of an individual and they oversee the payment of debts and distribute the assets of that person's estate. But not all assets can properly be transferred through the probate process because they're more so based on contract, and contractual language supersedes that of the probate process. Um, for instance, those documents might be, or those items will be your life insurance policies, some retirement accounts, or it's restricted to the terms of those retirement accounts. Same as life insurance. Life insurance is going directly to those beneficiaries in which you've designated that those assets should be distributed to. So you want to make sure you're checking those things that are directly tied to contracts. So if you have a life insurance and you said your mother was your beneficiary, but your mother has since passed away, you want to make sure and update that life insurance policy to make sure that you have a newer person as the beneficiary. Same with pay on death accounts. Pay on death accounts or putting a person to POD of your bank account. You want to make sure that that person is up to date and is the actual person that you intend to receive. Some of us have our spouses on our accounts. If you get a divorce, you want to update that, etc. Or if a spouse even passes away, you want to make sure that that's updated. Trusts do not pass through the probate process. Joint tenancies, that's like when you have a shared property and that person that you share the property with, because they are living in that property, they have what we call a right of survivorship. That right of survivorship is not going to go through the probate process. It is respected. That individual has a right to stay and reside in the space. And then inter vivos gifts. Inter vivos is a Latin term for in one's lifetime, basically. Any gift that you give to anyone during your lifetime, you can't then go back as the heirs of the estate, go back and say, hey, give that gift back, because the person that passed away intended for it to go to that person during their lifetime. And then smaller estates. Smaller estates is what we consider less than $75,000. Those will require a court order, and we do what's called a small estate affidavit to settle those. Next slide, please. What's an estate plan? An estate plan is the actual process that designates how you want your assets to be distributed when you actually pass away, or even if you become incapacitated. We have documents that we're going to go through and discuss in here in just a second that allow you to pre-plan for incapacitation. And that means like when you've lost all your faculties, or you could have gotten into a car accident that caused you a life-altering change. You're no longer able to make decisions for yourself. Those things are helping you. Those documents that we'll discuss will help you to plan for situations like that. And that's a part and parcel of an entire estate plan. But it can help you to also ensure that your beneficiaries are receiving those assets in a way that most of the time will help to alleviate some tax burden to them, or any other expenses to them. You want to make sure that once you pass away, your heirs are receiving the benefits of your life insurance policy, the benefit of your bank accounts, so that they can help and handle business on behalf of the estate. Next slide, please. So why does an individual need an estate plan? I would say that anybody that owns anything needs an estate plan, because you want to make sure that you're giving your loved ones a roadmap on how to distribute your assets when you pass away. It's like your wishes. If you want your loved ones to respect your wishes, then you need to give them guidance on what those wishes actually are. I think everybody has like that big mama, right? And Big Mama be like, they know what I want done with my stuff. They know how I want they know I want my china to go to Patrice or whatever. But she never wrote it down. It's all he said, she said at that point. Your estate plans allows your loved ones to have some guidance. It allows your loved ones to know exactly how or who you are considering the beneficiaries of your estate. Just because so and so had a child, does that mean that you really want that child to reap the benefits of your estate? Sometimes we have falling outs with loved ones. You might want to expressly disinherit someone. You might want to expressly allow someone to inherit that might not be family, right? So, or you might want to give a benefit of your estate to, say, a charity, right? You can do those things with your estate plan, but without it, there's nothing you can do. Like the state in which we're we reside in the state in which we are practicing in, the state of Texas, the state is going to go and determine whatever they want to based off of the intestacy laws if you have no estate plan. So it's basically proper planning allows you to prevent from your family members possibly making poor decisions about the things that you want, right? So a lot of us work hard, work very, very hard for the things that we have amassed over a lifetime. And you want to make sure that it's going to the intended beneficiaries. So I want to make sure that I'm touching every point on this though before we move on. You want to make sure that you establish the directives through the estate planning documents. You want to review your beneficiaries on any probate and non-probate assets. I talked about that earlier. If somebody passes away, you want to make sure you're updating that periodically. And then you want to plan to reassess everything, I would say, whenever major life changes happen, or even like maybe just make it a habit of every 5 years to make sure that you're reviewing and updating based off of things that you may or may not have anymore. So if you lost a home, or if you've sold a home, I should say, nobody's going to lose a home. If you've sold a home, you want to make sure that you're updating it based off of those things. We can go on to the next slide. Oh, I'm sorry. I saw something on that last slide that I did miss on children. If you have children that are incapacitated or children that need special care, you want to make sure that you're providing for them, and you can do so for those children or even grandchildren. A lot of people are taking care of their grandchildren or nieces or nephews, and you can do that through estate planning. It's okay. You can go on through that. Okay. So types of documents. With the way we provide our estate planning wraparound services for clients is that we provide most, if not more, of the documents that you see here listed, actually. There are different types of documents in the estate planning process that provide you with different types of benefits or different types of, we like to call it a roadmap for your loved ones, or a different roadmap for your loved ones to abide by. The will and the will memorandum. A will is exactly what I think everybody has probably seen in Hollywood. Like, oh, you know, I don't know if y'all saw like Aretha Franklin's son. There was an issue with her will recently. There was a written will that was found in a piece of paper in the couch, found somewhere in some random place, and so he had to go and contest the other will that had been presented in the court as being factually hers. But then it ended up that they decided that the one that was found in the couch was actually the most recent will. Well, a will is just basically a testamentary document. You're saying you have full knowledge and capacity and understanding of what is in your estate, or what we call your bounty. You have a full understanding of what's in there and exactly who you are delineating it to. You have full capacity. You're over the age of 14, and you yourself are expressly entering into this document for it to be your last will and testament. That is what we consider a will. It has to be attested to by 2 witnesses and signed by a notary as well. And the stamp has to be affixed on the document. A will memorandum can assist you in updating that will without having to redo the entire document all over again. So when we have life changes and things like that, like beautiful babies, and maybe someone or something is no longer in your bounty, then you can update that through a will memorandum. A trust basically allows you to, what we consider like pre-probating your will. It allows you to designate the property in the trust, that while you're still alive, the property that you want to go to different beneficiaries. It allows you to generally avoid probate as long as everything that you have in your estate is actually what we call funding the trust. You have to basically redesignate whatever that item is or those items are in the name of the trust. That's what we call funding the trust. And that is how you properly avoid probate. But if you have other things or other assets that you later acquire and you never put them into the trust, then the things that you never put into the trust before you passed away are now going to have to go through probate. So what we have what's called a pour over will that's being provided for that reason, with the trust. They kind of go hand in hand. A pour over will is going to be like a catch all for the things that you might have forgotten to put into the trust or might not have had the opportunity to put into the trust before you pass away. But it helps people preserve privacy, and it offers an asset in case someone offers to basically kind of protect assets if you later become incapacitated. The medical power of attorney helps you to designate an agent to make medical decisions for future incapacitation or during a medical procedure, because during a medical procedure you can't really make decisions for yourself. So the medical power of attorney allows the individual or the agent that you designate to make medical decisions for you in those times. Then there's the durable power of attorney. It's basically all financial decision making. The financial decision making is like, where's my bank account going to be in the event that I'm incapacitated? Again, these things, the power of attorneys come into place only during the individual's lifetime. Medical and durable are only during your lifetime, and they are only if you are incapacitated. People shouldn't be using your power of attorney. Powers of the agent don't come into play until you're actually incapacitated, and only during the individual's lifetime. So what I've seen is a lot of people think that just because they had power of attorney, they now think that they're the executor over the estate, and that's not always the case. Some people can have a designated power of attorney or agent. That is, the power of attorney may be their sister, right? But then on their will, they have as the executor of the estate as their firstborn child. They don't have to be the same people, but it does help for cohesiveness for it to be the same person. But the powers of attorney expire as soon as the person passes away. Then we jump into what the will goes into play as soon as the person dies. Those are two very different, distinct things that people like really, really need to understand. So I just wanted to help make that clear. Then the directive to physicians and family surrogates is basically telling them what you want to do in the event that you need to be put on life support, or do you want to be revived? Do you want to be resuscitated? Do you want to be taken off of life support? That's the directive to physicians. And then the declaration of guardian is basically if you're ever later incapacitated, you can kind of pre-plan or pre-designate who you'd like to be the guardian of yourself or of your person. You still, that person still has to by the court still has to uphold certain standards in order to be appointed a guardian. And I won't go like too far into the weeds, but they basically still have to be an upstanding person. They can't have any crimes or pending crimes against the person. Like and the person, by what we mean is just like crimes like family violence or domestic violence or assault and things like that, that the guardian, or even embezzlement, because the guardian would have to be the guardian of the estate and the guardian of the person. And guardianship, just like medical power of attorney, is only alive as long as the person is alive. It's only in existence as long as the person is alive. The guardian ceases once the person passes away. Then we go to the will or the trust and see what the person's wishes were there. Next slide, please. Okay, yeah, so that concludes my portion of the presentation. But basically, if you guys have any questions or need any consultation, you can definitely scan the QR code there or contact us on either one of these methods. We are pretty accessible in all platforms, and we'd be happy to answer any questions at this time. So, thank you. I see. Can I start reading the chat?
Yes. Yep.
Or are people coming off mute?
People, I came off. I wanted to ask, what are the typical costs associated for setting up a trust?
Yeah, so they can start as for an individual, start at about $2,500 and go up from there.
Okay. And I was trying to type real quick too. When would you want to set up an executor? Like I've heard of an executor of your trust fund or account. But if you're still alive, would you only want to name an executor after you pass or while you're still living?
So it's two different languages. With a will you'll have an executor or designated executor. With a trust, you have a trustee. The trustee is basically it's just language, a matter of language. So knowing what types of documents you're dealing with. Those people are designated when you create the document. What I will say to follow up for that is that when you tell the people that they have been designated is very important. Like you should be telling them before you create the document that I've designated you as my executor or I've designated you as my trustee. You want them to be in agreement with the responsibility that is required for taking on something as serious as somebody's estate, right? And you want that person or those people, because you can also have an alternative person. It's always advised to have alternatives. You want them to be willing participants, because in a lot of the cases, these people are also going to be grieving your death, because they're usually pretty close to you and things like that. But you want to make sure that they're willing participants in the ask, which is a very heavy lift.
Mm-hmm. Yeah.
So I have a question. Cynthia, you done? Can I ask a question? All right. Quick question. This is just for clarification for some folks. I guess what would say the difference between a will and a trust?
The difference between will and trust.
Mm-hmm.
For sure.
Mm-hmm.
The will is a document that has to be probated. It has to go through the court process.
Mm-hmm.
It is also a document where you designate beneficiaries. It can also be governed by the laws in which who are not governed by. I would say it would be actually enforced by the laws in which the state determines what a person's lineage is consistent of. So, for example, there be a phrase in the will that says all of my property goes to my children,
Mm-hmm.
right? And in a good will, you want to list out who those children are,
Mm-hmm.
right? But in the event or in the case where like maybe you had a child after you executed that will, the court is going to determine, well, what does the child mean in the state of Texas, right?
Okay.
Is somebody adopted by you or birthed by you? In the case of men, sometimes you have to go through a paternity suit, even in the probate process, to determine who that person's lineage is, who that person's children are, right? Whereas, so a will have certain clauses in it that kind of really reflect the probate statute in our state, right?
Mm-hmm.
A trust will have the same, but in a trust and a will, basically you can determine whoever you want the beneficiaries to be, but the The biggest difference between a will and a trust is that one goes through probate and the other doesn't.
Okay. Okay.
But I'll leave it at that.
Okay.
Okay.
Because
Okay.
there, in the law, in there's so many exceptions for things.
Okay.
Like the general rule is that it's one is probate, one is outside of probate. But
Okay.
um, when you fail to fund the trust, like I said
Mhm.
earlier, you can still end up having to go into the probate courts.
Probate. Okay. So one more question. Is the will to be effective, it has to go through or like you gave an example of Aretha Franklin. Let's say and the reason I'm presenting this is because I'm thinking about my audience. I just write something on a paper of paper and say this is my will. Is that a will? Or it has to go through a series of I don't know.
Ceremonial process.
Yes, yes, yes.
In the state of Texas, as long as you say that this is my last will and testament, you write that out, and it's wholly in your handwriting, the testator's handwriting. That means I wrote everything clearly on this piece of paper. It was all just in my handwriting. Can be partially typed and partially in handwriting. And I attested to that I have capacity, and I know that this is my will. Then it's a will, and you
Okay,
sign it, it's a will.
okay.
Now, whether or not it's you know, doesn't require the court to then call additional witnesses, then that would be another question for the court to determine, right? Even a handwriting witness would come and say, "Oh, this is his or her handwriting because she gave me a birthday card every year, and I know her signature." But as long as you have testamentary capacity, and you are of the age of majority, and you have witnesses sign on that document, then it's a will.
So will.
It almost anything could be. In law school, there was like a napkin. There's this case of a napkin that was determined to be a will because the person wrote on the napkin, "This is my last will and testament." I said, and I want these things to go to this person, signed little brother, and he wrote his signature on there, and it's his will.
Okay, okay.
I will say anything can be argued in court.
So now, this group is. I would just ask for your advice before folks come in with question. If we still have question, this is a group of folks who have purchased probably the first home. Some of them second. What would be your advice as a lawyer, as a trust lawyer? What is the next step? If I haven't done anything there, this is Patricia. I purchased my home 2 years ago. I'm very excited. I have 2 kids. What should I do? What is the next step?
You should get a will
Okay.
at minimum. You should get an estate plan that hopefully encompasses everything, because we can all die like just sitting here, right? Anything can happen to any of us at any time. And to have nothing is leaving it to the state to determine how your stuff is going to be allocated. That's not a scary thing. That's not to scare anyone or fear mongering or anything. But it's sorry.
It's okay.
Okay. That's not to scare anyone, but it is a very real reality. The state is going to determine what happens to your things if you don't.
Okay.
So I would say at the minimum, get a will. There are self-help measures now in the state of Texas. Texas Law Help is one of them. Um, and then there's us.
That's true. And I'm gonna open the floor for everyone. Just on a side note, guys. Sometimes when we talk about this stuff, we feel like it's far away from where we are. Believe or not, it's very close. I serve I serve all of you guys, but one of my clients, Cynthia, you remember this, he purchased a house 3 months later. His first payment, when it happened, he had a heart attack and he died. He did not have a
Yeah.
will. He did not have an estate planning.
Yeah.
And I remember what the family went through just to figure out what to do with that house. It was a heartbreaking, honestly. He didn't even make the first payment because when you purchase a house, you have 1 month in between where you don't pay anything, and then the third month he called me. The payment was gonna be on a 15, and on a 14 he called me and said, "Hey, I'm trying to make my payment, but I don't see anything online." So I stayed with him on the phone for 28 minutes trying to figure out who to pay, who's gonna be the servicer. And on the 16, I saw a post. People are saying goodbye to him because he had a heart attack in a car. He did not have an estate. The reason I know because they reached out to me. He didn't have anything in place. So really, guys, it's not as far as we think. It's not something is going to happen to you. Nobody wants that to happen to anybody. But I'm just saying the reason we invited the Elaine group is so then we can start thinking about this. This is all foreign to us. It's all new. But if we can really consider, ask her your questions, and then if she cannot answer them, if this is something personal, then set up an appointment where you can have a follow-up. All right. So we're gonna open you ask her your question. We're here to help.
Yeah, there was a question that Lillian had. She wanted to know what can be put in a living trust. What all can be put in that besides your home, any accounts? What all is that available to put in a trust?
You can pretty much find a trust with most like high asset type of things. Your home, so your home, there's a caveat to everything. So I'm just thinking about the caveats, but your life insurance policies, your anything that you own, you could put into the trust. The things that are not usually in a trust, I'll say that's probably the easier question. The easier way to answer you will be like your personal effects. So like your kitchen table that was handed down, or whatever that you want to hand down to someone, you won't put that in the trust. You'll more so put that in a memorandum or the will memorandum. You'll put, say, your personal driving vehicle. You're not gonna put that necessarily in the trust unless it's like an antique car that's high value kind of things. So yeah, bank accounts, the proceeds of a investment account, things like that might go into the trust.
Right.
There was another question that just popped.
Yeah, there's another question. Let's say I have a life insurance policy. Should I also put that in a trust?
Yeah, that's what I said. Yeah, you can definitely put a life insurance policy. The only thing about life insurance policies and things that are contractual, you want to make sure that the company you'll just call your company, the insurance company, life insurance company or whatever, and just let them know your intentions to put it into the name of the trust and see if if they have any requirements that maybe needed to be met before you can put that thing into the trust. Also, like your home, if your home still has a mortgage on it, some mortgage companies you have to know your mortgage clause or contact and speak with your mortgage provider and see if you put it into the name of the trust, it doesn't like accelerate the clause or something like that. So, or they want it paid off before you can put it into the trust or things like that. Some of us do have mortgage contracts that are like that. So those are things to consider. A lot of folks, though, if you paid your home outright and you're ready to go, then you just put it into the name of the trust.
Okay. All right. I don't see any question here in the chat. If you guys have a question, you can unmute yourself and ask. If not, we have about 1 minute to 7:30. I know we start late, but we are grateful that you guys are here tonight. So let us know what you think. Let us know if you have any question. Other than that, if not, our next class is going to be on, what is it, Cynthia? It's going to be 3 months from now. It's September, and we're going to talk about wealth transfer or creating wealth through real estate. We have an amazing speaker who happened also to be a lender, who's going to talk about it. And remember, we're going to have this every 3 months. Honestly, guys, we are doing this for you guys. So if you see any person that you know that have purchased with us, we call us our tribe, and is not part of tonight class, go and share the news. So then 3 months from now, we can have them. And then when you register yourself, RSVP, make sure you show up, because we are taking time away from our family to be here and share with each one of you guys. Looks like there's one question here. Does that mean we can put our home in a trust only if it's paid off? Oh, you just responded.
Oh yeah, sorry.
No, it's okay. So, but at least
I,
everyone else who was not reading. Yeah.
No, go ahead. I'll read it. This the question. Follow up question was: does that mean that we can only put our home in a trust only if it's paid off? And my response to that is no. It's really like based off of the contractual agreement that you met with that mortgage company. You need to find out what's in that contract. A lot of us don't read contracts that we sign and then we enter ourselves into. So you just want to make sure that you won't have any problems if you attempt to put it into the name of the trust.
Okay.
How long does the process usually take? For changing your assets into the trust name, that really depends on how many assets you have. I don't know. It's, you have to title things over into the name of the trust, or deed things over into the name of the trust, that have a deed on them, like a home or a title. If it's a car or a insurance policy, you have to go through and change out all those insurance documents. So I really don't know how long it would take for all of those. Honestly, it can vary
Okay.
person to person.
Okay. Can you change? Can you do back and forth between trust and taking an asset out of trust and put it back and put it? And the reason I'm asking this is because, let's say, a whole life insurance, right? You can use that as an investment also as your bank, and you keep taking asset out and flip and put it back. Can you keep on doing between trusts, or that's something you will not advise, or it's not going to be possible to be doing back and forth?
I mean, so it depends on the type of trust I didn't go into this in the presentation, but there are lots of different types of trusts. The most common are revocable or irrevocable. Irrevocable is very self-explanatory in the title. I mean, you cannot revoke, you cannot take things in and out. Like you can't do that with the irrevocable trust. With the revocable trust, which is what's usually advisable for people, that it also depends on like your wealth management profile, right? Too, right? Like how high in the wealth sphere are you, or spectrum are you, or low, or in whatever. It's a spectrum. Everybody has wealth in some way, and you have to determine where you are on that trajectory and how much wealth you're trying to protect or need to protect, as to whether or not you want to do an irrevocable or revocable trust. Also, maybe your age could be a factor too as well. Like, am I of the age where I'm probably going to be moving a lot of things around? And a revocable trust probably is going to suit you better than an irrevocable trust, because irrevocable requires a court order to take things in and out of it. That's why it gives you those tax benefits. It gives you some protections from creditors with the irrevocable trust. A revocable trust allows you to move things in and out. You can change things. It's a living trust. You change things, and however you feel, you can do that.
Okay.
Revocable. Do you want to keep doing that? Probably not. Like not excessively,
Uh-huh.
because it like to the first question, the question prior to this was, how long does it take? The process can take a while to be doing that. And do you want to keep doing that over and over again? Probably
Okay.
not.
Okay. So my
But
last
you'll have,
question, no, go ahead.
all
No,
right,
go
I
ahead.
know it's late, but you'll have a pour over will that's put, if you come to us, you'll have a pour over will that's put in place that protects any of those kind of like transition periods that it sounds like that you would be worried about. That would still kind of be as like that bridge, that gap, kind of like gap insurance coverage.
Okay, yeah.
The will pour over will stands in the gap of things that aren't put into the trust and stuff.
Okay. One last question, unless if somebody has a question from me at least. When you have something on a trust and you get sued, can they sue your trust? Can they sue the assets that are under the trust? Are they protected or not?
So with the irrevocable trust, it provides more protection.
Okay.
Revocable because you're able to touch those assets, it doesn't necessarily provide all those protections. Like for instance, a creditor suit or something like that, it won't necessarily be protected under the revocable trust. With the irrevocable trust, you get way more protection.
Okay. Okay. All right.
Well, thank y'all, and thank you for bearing with us with the
Thank
technical
you so
difficulties.
much. Yeah, thank
Hopefully,
you.
we can help you guys in any way. Just definitely feel free to give us a call, or follow us on social media. It's right over my head that way.
And I put the information on guys, I put the information on the chat, but here here's the information again. Make sure you scan the QR code, get the phone numbers, email, and website. Like she said, follow them on the social media. They're amazing. Let's support them and also help yourself, honestly. Again, looks like there's no other question. We thank all of you guys for being here tonight, and look out for another invitation for September. September, we're going to have another class. Thank you.
Thank you all. Thank you.
Thank you.
Bye-bye.